to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a determination on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing your loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. Okay, are we ready on Ms. Johnson's matter first, I think? Looks like. All right, this is CR 2010-101760, State of Arizona versus Elizabeth Joanne Johnson. This is the time set for oral argument on pending motions. Would counsel please state their appearances?
Good morning, Your Honor. Angela Andrews and Elisa Rumino for the state.
Good morning.
Good morning, Judge Mark Victor Charity Clark for Elizabeth Johnson, who's present in court in custody.
Good morning. Okay, we've got, I think, at least three motions that are on the table, two of which we probably need to resolve today. One relates to the scope of Logan McQuarrie's testimony. One relates to the scope of Frank McQuarrie's testimony. We also have the issue relating to Tammy Smith's statements. I'm not sure we have to resolve that this morning. It's something we've talked about before, but we certainly need to talk about both Logan and Frank McQuarrie's testimony. Let me start out with asking whether anyone filed anything. I didn't see anything that got filed between the last time we talked and now. Is that correct?
That's correct.
Okay, good. I didn't miss anything. All right. And let me start with the state, because I think part of what we needed to do over the weekend was for the state to see what it intended to do with both Logan and Frank McQuarrie in terms of testimony, so that we could see, do we have an issue from the defense perspective and the scope of that issue. So, Ms. Andrews, let me start with you in terms of what you expect to elicit from Mr. McQuarrie, and specifically any testimony relating to his state of mind, because that was the specific subject of the defendant's motion.
And, Your Honor, I will tell you that defense counsel and defense counsel and Ms. Rumino had conversations both in person or on the telephone and email all through the weekend. And we think we have some agreements on what we agreed to and some issues still in dispute.
Okay.
And so in regard to Frank's testimony, my understanding is the defense is no longer requesting to preclude him altogether, but there are certain things they'd like to preclude from his testimony. And, Your Honor, I can give you a list of those items, and then we can talk about them, perhaps.
Okay.
One of the things they want to preclude is from Frank testifying about any observations he had of Elizabeth Johnson with Gabriel.
Okay.
They want to preclude any testimony about Logan's demeanor during any of the offenses that happened, the dates of the offenses that happened. Specifically, one of the things I indicated that I was probably going to ask him about is what was Logan's demeanor after talking to the Smiths, what would Logan's demeanor be after talking to Elizabeth Johnson. And I intended only to ask Frank to describe what he saw physically as far as Logan's demeanor, that he cannot testify as to Logan's state of mind.
Okay.
I know, Your Honor, in the first trial, I did ask Frank some questions such as how he himself, Frank, felt about the whole custody situation. And I asked him about Logan's reaction to the custody situation. And I agree that those are probably more appropriate for any aggravation phase, if there is one.
Okay.
And I believe those are the only issues we had in dispute in regarding Frank's testimony. One thing I'm not sure I talked to defense counsel about is I do intend to elicit from Frank what he would see with Logan and Gabriel in their interaction. And I don't know if they dispute that one.
Okay. All right. So, Mr. Victor, Ms. Clark, let me go to you. In terms of observations of Elizabeth Johnson with Gabriel, and again, we're talking about Frank McQuarrie. I will tell you I have some concerns about that. It goes to the ruling I made relating to Ms. Johnson's alleged statement about get that thing. The testimony related to her parenting skills or how she was doing is going to have limited probative value and a lot of prejudice from my perspective. And I'm concerned, especially Frank McQuarrie testifying about her parenting skills. That gives me great concern, Ms. Andrews, and you're going to have to really show me how that relevance, there's a lot of relevance there, because I don't really see it. That's my initial thought. So I guess you don't have to say anything on that issue, because if you're objecting, I tend to agree with you, Mr. Victor, on that issue. Logan McQuarrie's demeanor, I guess my concern is that we don't backdoor his state of mind or how he reacted. Demeanor can easily turn into how did he feel about that. And I think under the circumstances, Frank McQuarrie's observations of how Logan McQuarrie felt, again, I think it's limited relevance, and while the prejudicial value isn't as great if we're talking about directly Ms. Johnson's parenting skills, I'm concerned about that. So I guess why would you want to be eliciting the demeanor would be my question to you, Ms. Andrews.
Well, Your Honor, and it's really a point that you made the other day when we were here, is we have to show Elizabeth Johnson's intent. I have had a lot of experience in child abuse type cases, and I know there's not a child abuse charge here, but there is a kidnapping charge. And we have to show that Elizabeth Johnson intended to place Logan McQuarrie in reasonable apprehension of imminent physical injury to a child. What I know is that juries have a difficult time, people in general have a difficult time, that a parent would do something like what we have alleged that Elizabeth Johnson has done in this case, to use their child as a pawn or to say that they killed their own child. And so some background into Elizabeth Johnson's relationship with Gabriel and Elizabeth Johnson's relationship between Gabriel and Logan, and the experiences that Logan has had in regard to Elizabeth Johnson and Gabriel are important as background to show Elizabeth Johnson's intent. Otherwise, it's nothing more than just an empty statement. And I think we have the right to be able to show the jury that this isn't the first time that she's come from this position and used Gabriel in a situation against Logan or to attempt to hurt Logan. And that's exactly what we believe the prior relationship between Elizabeth Johnson, Gabriel, and Logan McQuarrie shows.
Okay, that and tracking my previous 404 ruling, I agree that previous issues relating to her alleged attempts to use Gabriel Johnson against Logan McQuarrie, that's probative. It generally comes in. I worry about, though, going outside of that specific use. I precluded testimony regarding the alleged incidents with the apartments because that went outside the use of Gabriel Johnson and the alleged use. I think that Frank McQuarrie's observations of Elizabeth Johnson with Gabriel are still outside, I think, any real probative value here. And I'm going to preclude testimony from Frank McQuarrie observing Elizabeth Johnson's parenting skills. I agree with you in terms of the effect or the demeanor of Logan McQuarrie. I think under the circumstances that completes the story to some degree. It is probative to some degree of intent if there's an ongoing relationship or alleged attempt by Elizabeth Johnson to affect Logan McQuarrie. I think it's fair to get into that. I want it to be limited. I don't want there to be a lot of testimony from Frank McQuarrie just talking about how Logan felt. I think we get far afield there. But limited testimony as to Logan's demeanor I think is appropriate. So I agree with the defense with respect to Frank McQuarrie's observations of Elizabeth Johnson as a parent or her interactions with Gabriel. I think that comes out. But he can testify with respect to Logan's demeanor. I haven't given Mr. Victor a chance to say anything on that topic. Anything you want to add for the record?
Judge, I think your ruling could be construed as very broad. When you say Mr. Frank McQuarrie gets to testify about Logan McQuarrie's demeanor, I'm not sure exactly what that means. His demeanor doesn't have anything to do with his words. That of course, I would expect wouldn't cover anything that Logan would say. Are we talking about he was fidgety, that he had a certain look on his face that I interpreted this way or that way? I'm not exactly sure what we're talking about and what the context is. I'd like a little bit of context just so we can understand, so there's an appropriate size of the leash here in terms of how we're going to deal with this testimony.
Probably a fair request. Can you be a little more specific as to what you plan on asking Frank McQuarrie?
Your Honor, specifically about physical demeanor, what he saw as far as Logan's physical reactions, maybe what he saw, not words, but what he saw in his voice. Was it shaky? Was he crying? Those types of things. Only physical demeanor only. And Frank McQuarrie understands that. He's a retired police officer, so he understands the difference between statements and demeanor. So I think I could easily guide him through the difference between words and not words.
With that explanation, I think I'm comfortable with that. Again, we'll have to keep a careful track of where we're going and make sure Frank McQuarrie understands the extent to which he can talk about Logan McQuarrie's demeanor. Mr. Victor, anything else from your perspective on those topics?
Well, Judge, I thought we had broken down the demeanor issue into two groups. The group of what was Logan's demeanor like when he was speaking with Tammy Smith, and then the other group, what was Logan's demeanor like when he was talking with Elizabeth Johnson. Is your ruling for both of those groups or one of those groups? And if so, which? Because I think they're different.
Well, I think they are different. The probative value of his demeanor when talking with Elizabeth Johnson or that topic is far more probative than the Tammy Smith. I understand she's alleged to be a co-conspirator, but how Logan McQuarrie reacted in his discussions with Tammy Smith or what she said to him has less of a probative value from my perspective. It's still part of the conspiracy allegation. I think on a limited basis it can come in, but I do think that there's a lot more probative value to the Elizabeth Johnson interaction.
But Judge, if we're just going to have testimony that Elizabeth Johnson was doing things that could be interpreted as she's a bad mom, and Mr. Frank McQuarrie, what did you observe of Logan McQuarrie at that time? Oh, he looked this way and that way and this way. Isn't that really just backdooring in testimony about she was a bad mom?
No, I think it depends on the context, and I'll be aware of that. If it follows testimony about Elizabeth Johnson doing something to Gabriel, yes. If it follows testimony about a conversation Elizabeth Johnson had with Logan McQuarrie, no. And that's what I'm interpreting the state's request to be.
Okay, Judge, so just so we're clear, so maybe I'm clear, we're not talking about Frank McQuarrie's observations of Logan McQuarrie in regards to whether Elizabeth Johnson was being a good mom at the time.
That would be a backdoor way of getting in what I just said can't come in.
All right,
and I think Ms. Andrews recognizes that.
Okay, Judge.
Okay, all right. So with Frank McQuarrie, I think I heard an agreement that how Frank McQuarrie felt or how Logan McQuarrie felt is not going to be elicited. And I think that covers Frank McQuarrie as best we can at this point. Anything else on Frank McQuarrie before we talk about Logan McQuarrie?
Not from the state, Your Honor.
Okay.
Could I have a moment, Judge? Judge, we didn't address these issues about whether Frank and Elizabeth Johnson got along or didn't get along or the nature of their relationship. So I'm assuming from that, and putting on the record so I don't have to assume, that we're not getting into those types of issues with Frank McQuarrie.
Are we going to ask Mr. McQuarrie about his relationship with Ms. Johnson?
Actually, Your Honor, I was. And I didn't have that written down in my notes, but defense counsel and I did talk about that over the weekend. And Your Honor, the reason for that is there are text messages between Elizabeth Johnson and Logan McQuarrie and text messages between Tammy Smith and Logan McQuarrie that refer to things about Logan and his dad. And essentially, from the first trial, all Frank testified to is they just didn't get along very well and she didn't like him.
And I think that's fair because of the context, it puts into context the text messages that the jury will presumably see. Why they didn't get along shouldn't come in. This doesn't mean that he can back up the dump truck and talk about all the things he didn't like about Elizabeth Johnson. Can he testify that they did not get along and that she didn't like, his perception was that she didn't like him? Yes. Why? No.
Judge, I'm not sure what the relevance is. I mean, how's it relevant to anything that Frank McQuarrie didn't like Elizabeth and Elizabeth didn't like Frank? I'm not sure how that's probative to any issue that's of consequence here.
Because there are text messages that are going to come in along the lines of run to daddy, and there's going to be information in those texts that relates or appears to relate to Frank McQuarrie, and I think it's fair to put that into some context in a limited way for the jury.
Judge, and I'm really not even clear about how those text messages are going to be relevant to any issue in this case either. This run to daddy stuff. I mean, I'm failing to see how that's relevant to anything.
I think it's relevant because it goes to her intent, whether her intent is to put Logan McQuarrie in some fear or concern about the whereabouts of Gabriel Johnson. So I do think it comes in. We've had this conversation before with respect to those text messages and your attempt to limit or exclude some of them, whether it's relevance or cumulative. That particular text is coming in.
Okay, Judge, so the text messages are in. I think there may be some pictures. I think they were on Facebook. I don't know if there's going to be testimony about how Frank felt about pictures that were on Facebook. Is that something that the state's intending to bring in?
How Frank felt about anything is going to be hard for me to see how that's coming in. His observations, he's basically a witness that's going to testify as to his observations of what was happening. So how he felt about something, I don't think that's ever coming in. That he had a difficult relationship with Elizabeth Johnson, that can come in, but not why. How he felt about it, no. Did they not get along? Did he perceive that she didn't like him? That comes in. Okay, anything else on Frank McQuarrie?
No, Judge.
Okay, we'll talk Logan McQuarrie. What have we agreed to and what do we not agree to?
Your Honor, regarding Logan McQuarrie, I don't believe that there is an agreement as to anything regarding his testimony, regarding his state of mind at the time of the crime. It's the state's position that we do not intend on eliciting some long narrative about how this has affected his life in general or anything of that nature, but we are limiting it to those days that he was in reasonable apprehension and fear for the safety of his child. The element that the state need to prove is that Elizabeth Johnson restrained Gabriel Johnson with the intent to place Logan McQuarrie in reasonable apprehension of imminent physical injury to Gabriel Johnson. And the state feels that it is relevant what his reaction to her statements, to her texts were at that time. Because not only is it in the element itself, but it's also relevant to show why he did what he did in the next few days. The conversations that occurred between Logan and Elizabeth on December 27th, there is some room for interpretation of the things he said that day, the things she said that day. For example, at first during one of the conversations that they have, he makes statements like, "Oh, you didn't kill him, you didn't do that," because I think he's in shock, perhaps some disbelief at that time, but later on as the conversation continues and goes on and on and on, he obviously is in reasonable apprehension at that time because he hangs up the phone and he calls the police. Those are the state of mind statements that we are seeking to elicit from Logan McQuarrie.
Okay. Go ahead in response to that.
Judge, whether Logan McQuarrie was indeed in apprehension of imminent physical injury to Gabriel is irrelevant to this case. The statute focuses solely on Elizabeth Johnson's intent to put Logan McQuarrie in fear of an imminent injury to Gabriel. Whether or not he says, you know, I didn't believe her, I really was never in fear at any time, or whether he says, I believed everything she said, I really thought she was going to hurt Gabriel at some period, it's just not relevant to this case. It has nothing to do with this case. And so to allow that type of testimony in, especially in the context of this case, is horrendously prejudicial. That's why at first we argue that there is no relevance, and I don't think we get past that issue because there just is no relevance to Logan McQuarrie's state of mind.
Let me ask you this though, isn't it somewhat probative of, let's say, an archer's intent to hit the target? The fact that he hit the target, doesn't that to some degree, isn't that relevant? In other words, the fact that the state's alleging that she hit the target, isn't that somewhat probative of whether she was aiming at the target?
Not necessarily, Judge.
Well, maybe.
But in the problem with even that marginal probative value here is the overwhelming 403 prejudice that comes with that issue. We're not talking about whether an arrow hit a bullseye here. We're talking about things like, is a baby dead? is a baby missing? Those are overwhelmingly prejudicial type issues. And I think that even if you put the prejudice aside, the potential for confusion to the jury is huge. It's easy for me to see that the jury could be sitting there in the box hearing about, well, was Logan McQuarrie really in fear? Yeah, I think Logan McQuarrie really was in fear. It's going to be very difficult for them to sort of peel that apart if that testimony comes in and not focus on whether Elizabeth Johnson was intending that.
But it also puts into context, and I think it is a fair and important argument. He makes some statements in the phone call that the jury's going to hear saying, no, you didn't do that. No, you didn't. And essentially disbelieving that she did any harm to Gabriel Johnson. I think it's fair to let him put that into context in terms of how he felt about that, because you can use that against him later and say, hey, he wasn't worried about it at all.
But Judge, it's just not relevant. If they could move, if they wanted to exclude that statement from that recording and say, you know, the statement that Logan McQuarrie makes where he says, no, you didn't, that's not relevant, and that could be prejudicial. They could certainly move and take that position and try to preclude me from bringing it in and harping on it, because it's not about his state of mind. And even if you keep that statement in, that's going to draw focus to his state of mind. And I don't think it's going to be hard, Judge, for the average juror to believe that he really was in fear about things in this case. And so we don't want this case decided on an irrelevant issue, which is, I think, what's going to happen, either because of prejudice from the 403 prejudicial issue or complete confusion over whose state of mind they're to focus on.
Well, going to your last point first, we presumably can properly instruct the jury as to whose state of mind they should be focusing on. And we can specifically instruct them that they're not to focus on Logan McQuarrie's state of mind. That's not an issue for them to determine. It's Elizabeth Johnson's state of mind. I think to some degree it completes the story to a limited presentation. I don't want there to be multiple questions about how Mr. McQuarrie felt, because at some point the 403 prejudice outweighs the probative value. I think directly relating to the conversations that occurred within the time frame, a limited set of questions regarding his belief or state of mind is appropriate, but it's got to be limited. It's hard for me to define it exactly. And I will tell you, I have a concern, having gone back in and read Logan McQuarrie's testimony from the Tammy Smith trial that was provided to me. It wasn't all of it, but it was part of it. There were questions to Logan McQuarrie such as, how did you feel about being accused of kidnapping again? That shouldn't come in. That's relating to the December 8th and 9th events going forward. How Frank McQuarrie felt about the custody hearing. Logan McQuarrie's impression of Tammy Smith's motives, again, how he felt about things. We have to be careful about those types of statements coming in, what his opinion was about why somebody was doing something. But I think that it is probative, and the probative value outweighs unfair prejudice on a limited basis for Mr. McQuarrie to testify regarding how he interpreted, how he felt about certain statements of Elizabeth Johnson within the time frame. It's got to be limited, and it's hard because I can't exactly define it. There is the potential for 403 mischief here, but I do think that there is a probative value, and it does complete the story, and it explains comments that Mr. McQuarrie made during that conversation as well. For those reasons, I think it comes in on a limited basis. And I would obviously instruct the jury that that's not, Logan McQuarrie's state of mind is not an issue for them in this case.
So, Judge, I'm just trying to understand the ruling. I guess what you're saying, and you can correct me if I'm wrong about this, but the state can ask Logan McQuarrie, were you afraid that Elizabeth Johnson was going to harm Gabriel?
I think they can on a limited basis within the context of that one conversation.
Okay, Judge. That's your ruling. I understand it.
I know you disagree with it,
I do.
but it's limited in that context. And again, my ruling's based on the ability to instruct the jury as to the appropriate state of mind or whose state of mind is relevant to their determination. Okay, so we've got Logan McQuarrie's state of mind. What else with respect to Logan McQuarrie's testimony do we know right now might create an issue?
Your Honor, I have a question in regard to the state of mind. As the court recalls from the first trial, Logan McQuarrie had a phone call with Tammy Smith when after Gabriel Johnson was missing or after Elizabeth had made the phone call. In that first conversation, I don't know if you recall Logan testifying he thought she was a nice lady. And then there were additional conversations with Tammy Smith and Jack Smith where they were telling him he needed to sign adoption papers. And then how he felt about that situation changed. He indicated that he then started to feel like as though they were pressuring him to sign these adoption papers or he would never see Gabriel again. Can I ask or elicit some testimony from Logan McQuarrie about that situation?
Mr. Victor?
Do you have a moment, Judge? It doesn't really matter to us how Logan McQuarrie feels about Tammy Smith, so we don't have an objection on that point. But I do have several other areas about Logan McQuarrie and his testimony in the Tammy Smith case to things that I think are just character evidence that I would like to bring up at the appropriate time and preclude.
Now's the appropriate time, but let me let the state raise any other Logan McQuarrie issues that they have. I'll let you raise yours.
And Your Honor, I will, because this may address some of Mr. Victor's issues. As I was going through and preparing for Mr. McQuarrie's testimony and keeping in mind the court's previous rulings about from the 404, I went through and I just wanted to clarify some things before the court guided Mr. McQuarrie on what he can and cannot testify to.
Yeah.
One thing that came out in the previous trial is that when they found out that they were pregnant with a baby, Elizabeth wanted to have an abortion. I do not intend to discuss any of that with Mr. McQuarrie. That won't even come up.
Good, because that was something I tagged in the transcript and I didn't think should come in.
Your Honor.
And let me interrupt you for a second. Mr. McQuarrie's here, so I don't have to repeat it. Listen to the things if you can. If you have any questions, let me know. I know there's a lot of information, but the types of things you can and can't talk about. And we'll try and help you while you're testifying. If I stop you, it's probably because I feel like you may be getting into an issue that you can't talk about. But what Ms. Andrews just said now, there was testimony in the previous trial about Ms. Johnson allegedly initially saying she wanted an abortion. That can't come in. So she's not going to ask you directly about it, but make sure it doesn't find its way into one of your answers to another question going forward. Go ahead, Ms. Andrews.
Your Honor, the court ruled that we can get into testimony about Elizabeth taking Gabriel and going to Boston in June of 2009 when she met Tammy Smith. In looking back through what Logan has testified to or told the police about that situation, that's intertwined with some of the information the court has precluded.
Yes.
And so essentially what he indicated is that he got released from jail, he came home, she was angry because he woke up the baby, and then they got into a fight. And she said she was leaving, she had threatened to hurt the baby, so he called the police. The police actually came and did a welfare check, and when the police showed up, the apartment was destroyed. And then she accused Logan of doing it, and the police found that it wasn't Logan because it was all his stuff that was destroyed and not Elizabeth's stuff that was destroyed. And then she came back, and then she eventually left to Boston the next day and took the baby to Boston. I'm assuming, and I'm intending to avoid any conversation about her threatening to hurt the baby, her destroying the apartment, the police being called. She blamed it on him. Although I will tell you, it's the state's position that all these prior incidents are relevant. It was our position in the 404 motion, but based on the court's ruling. So what I believe we would testify is did you guys get into an argument? Did she then take the baby to Boston, and what happened from there? He then testified that when she decided to come home, they had to move into a new apartment. While I may talk about them moving into a new apartment, I won't talk about why they moved into a new apartment and that it was destroyed and they got kicked out of the apartment. Although, once again, for the record, it is the state's position that that is irrelevant. And so, Your Honor, I'm going to ask the court, and I've mentioned it to defense counsel, if through some of these incidents where the criminal damage that can't come in is intertwined, if I could just lead Mr. McQuarrie a little bit through those.
And I'll be aware of it. Presumably, Mr. Victor will be aware of it. And if I feel like you're leading to avoid an issue, I'll overrule an objection in that regard. But I agree with you, and I was concerned about the Boston situation because it did immediately follow the allegations of the apartment damage, which I precluded.
And Your Honor, there was a second incident of apartment damage that occurred around September 2009 that I know that we can't get into. There was an order of protection filed by Logan McQuarrie, and based on the order of protection, Gabriel then went with Logan to live with his father. I do intend to ask Logan about a time in which he and Gabriel lived with Frank, but not the criminal damage or anything leading up to it, mostly just to show Logan's experience with Gabriel and that he has been a father to him and taken care of him. But I wasn't going, I mean, perhaps I can ask the court if you got into an argument and did you take Gabriel to live with you for a period of time?
I think that's fair. As long as you make a generic argument, I'm okay with it.
And then, Your Honor, there was the argument on December 8, 2009. You already ordered that we can't have Logan specifically say what Elizabeth said about taking that thing with you when she told him to take Gabriel, but that he can testify that she told him to take Gabriel with him and that he in fact did. And that's the date when she called the police and alleged kidnapping, and Logan had to return Gabriel on that day.
That can come in.
And then we have the incident on December 9th, which we're going to have testimony about where she showed up at his work and alleged kidnapping. And I don't believe the court has precluded us from talking about anything on that incident.
That is correct.
And then I believe, I'm double checking, Your Honor, but I think those are the areas that I saw that we needed to clarify. Oh, I did have one question. You had indicated that the detective, to some degree, could testify that the investigation is ongoing. Logan McQuarrie did some investigation of his own into the whereabouts of Gabriel, separate and aside from the police investigation. Is he allowed to talk about that at all?
No, because I think that begins to push us into where is Gabriel. I think you can get into, as we indicated the last time he saw Gabriel, that's fair, and from the detective that the investigation's ongoing, that's fair. But having him talk about that he's continuing to investigate and can't find him goes beyond where I think we ought to go on that issue.
And Your Honor, for the record, the state believes that's relevant because it goes to the defendant's intent to place Logan in fear. The fact that he then spent his time trying to find his son, we believe is relevant to the case.
And I think any limited probative value is outweighed under Rule 403 from the potential for unfair prejudice, so I would preclude that. Mr. Victor, what other issues do you have relating to Logan McQuarrie?
Judge, I have sort of a laundry list of things that I saw that he testified to in the Tammy Smith case, some of which I think are resolved. I can go through them and maybe we can just talk about them briefly. He testified that Elizabeth Johnson would, quote, fly off the handle. I think that's something that should be precluded. I don't know that we talked about that specifically. That just says she's got a bad temper, she does, bad things when she gets angry, those kinds of things.
And it's funny because this is on page 17 of the transcript. He testified, quote, she would get pissed off about things, just small things really that didn't really need to be blown out of proportion, and when she would get pissed off, she would just fly off the handle. I think we start getting into, again, testimony about the relationship and her volatility. I want to stay away from that in Mr. McQuarrie's testimony. You can testify that you had conflict. I'm okay with that. I just don't want this to get into a tit for tat. Here's what she did, and she had this issue going forward. The other thing I saw, well, go ahead, Mr. Victor, because I have a few.
Okay, Judge, maybe I'll cover them, I don't know. Testimony, Elizabeth Johnson didn't want Gabriel, wanted an abortion. I think we already spoke about that. That is out.
Yes.
Okay, testimony that they had altercations. Generally, I think that's in.
Yes.
Gabriel went to daycare because Elizabeth wanted to go and just do things. To me, that's character evidence. It's just saying she's not a good mom. The implication is that she didn't really care about Gabriel. She was out partying or shopping or having a good time, and that's why we had to put him in daycare, and I think that's just bad mom stuff.
No, I highlighted that. There was some testimony saying she didn't want to stay at home and take care of him, but there was also testimony that she wanted to go to school, that she tried that, it didn't work out for her. This dovetails into a question: how was Elizabeth as far as taking care of Gabriel? I want to be careful there because, again, it gets into the parenting skills. Her direct contact with Mr. McQuarrie saying, take the baby, that's okay, and the accusations of kidnapping, you get into that. But I want to be careful about, she was a lousy mom coming from Mr. McQuarrie. I don't want to turn this into essentially a family court case here. This isn't about her parenting skills. This is about how she responded to the conflict and essentially whether she meets the element of the offense. And I agree that testimony regarding her parenting skills doesn't really get us there.
Not clear on the answer here, Judge. So they get to testify that, or bring in testimony that basically Elizabeth put Gabriel into daycare because she just was out wanting to do things during the day. And I know you sort of alluded to the things might be school, but that got me into the next thing I wanted to talk about, which was there was some testimony that she quit going to school after she got all the loans, which kind of made it seem like she was going to school only for the loans, sort of some kind of a fraud or something along those lines. And I think none of that's relevant, and the jury could sort of infer bad things from that.
I don't think that was the intent of the testimony. I read it too. I think he was just relating historically, but I don't want that impression to be left, so we shouldn't talk about loans and what she did with them or didn't do with them.
So the daycare, she put him in daycare.
Let me ask, what was your intent with respect to asking questions about putting Gabriel into daycare? Because there were some specific questions that were asked.
In that previous trial, Your Honor, that was, I mean, if you recall, and that's why some information was admissible in that trial and not admissible in that. For one, because the prejudicial effect is different, but because of Tammy Smith's allegations about Logan not being involved in Gabriel's life, Logan not being a good father, Logan never paying the bills. I mean, the testimony about the daycare came in because Logan paid for daycare. Logan put Gabriel into daycare, paid for Gabriel to go to daycare, dropped him off and picked him up.
I agree. And that also related to her acts because he had to essentially defend what Tammy Smith was saying, and I let it come in for that reason. That's different than our status here.
It has some relevance here, Your Honor, because there is a recorded phone call between Elizabeth Johnson and Logan McQuarrie where she claims he was not involved in their life. And unfortunately, I don't have it with me because I didn't know we were going to discuss it. But she specifically tells him that he was not involved in the life. She was paying all the bills. He wasn't doing anything at all in regard to Gabriel. And unfortunately, I don't have that exact statement with me. Logan's not going to testify to the exact statement today. He's going to testify as to what he remembers from the conversation. But, Your Honor, she specifically makes those allegations against him in that phone call and in the response to the petition for custody. And so that's all we believe relevant as far as Elizabeth Johnson in that regard. But it was not my intention for him to testify in this trial that he put Gabriel in daycare because Elizabeth Johnson didn't want to take care of him. Just to talk about the fact that he put him in daycare, that he would pick him up, drop him off, and that he was paying for the daycare from the money that he was making from the job that he had.
That's fair. It's one thing, though, for him to respond to some allegation that he wasn't a good father by explaining all the things that he did. It takes it to another level by turning around and saying she was a bad mother. That's what I don't want. I don't want suggestions that her parenting skills were bad or that she didn't care, because that's really not what this case is about, and we really run the risk of a tremendous 403 effect there. So he can, of course, testify regarding what he did, his parenting role. That's fair game to respond to that. But then taking another step and saying, by the way, she didn't do this, or I had to do it because she wasn't doing her part, that's what I don't want to get into.
Okay, Judge, so Logan McQuarrie can testify that I did these good dad type things, but he can't say the reason Gabriel went to daycare was in essence because Elizabeth wanted to do things other than being a good mom.
No, because that statement, as Ms. Andrews said, came in the context of the allegations in the Tammy Smith
Okay,
case.
Judge. And of course, we're not making an issue out of whether Logan was a good dad or not, and if we open the door to that, then things might be different, I understand. He previously testified Elizabeth Johnson destroyed the apartment on a couple of occasions. I understand that is out.
Correct?
Broke windows, got arrested, that's also out.
Correct?
Elizabeth called police saying Logan's dad kidnapped Gabriel, that is in.
Correct?
Elizabeth didn't visit Gabriel much when he stayed with Logan's dad. That should be out, I would think.
That should be out. Again, that goes to the skills.
I'm sorry, can you repeat that?
That Elizabeth didn't visit Gabriel when Gabriel was staying with, I think, Frank, correct? When Logan was staying with Frank.
Right. Elizabeth just didn't come to visit much. My understanding of the court's analysis here is that ought to be out, but the court hadn't yet ruled on that.
It should be out.
And then take that thing with you is out.
Correct?
Elizabeth didn't do a good job taking care of Gabriel. I assume that is out.
Correct?
And I think that's about all that came in that was objectionable.
Okay? All right, anything else the state sees that we need to talk about?
Your Honor, no, I just need some clarification, mostly for Logan's sake. In regard to the incident where Elizabeth called the police and said Frank kidnapped Gabriel, what happened is that was when she was arrested for criminal damage, and so Logan called Frank and had Frank pick up Gabriel from daycare, and then when Elizabeth got out of jail, she then called the police and said Frank kidnapped Gabriel. So we're only going to be able to talk about there was a reason, or talk about there was an incident in which Logan had Frank pick up Gabriel from daycare, and then Elizabeth contacted the
Because you
police.
volunteered in the previous case that she got out of jail and then she did something. We can't talk about her getting out of jail or that incident, but he can talk about the facts that he had his father pick Gabriel up.
Judge, I'm just, in light of the court's ruling today, that in essence that Logan McQuarrie gets to testify that I was afraid that Elizabeth Johnson was going to do something to harm Gabriel, I think it makes sense to request a limiting instruction on that point at the time the testimony comes in, probably after the testimony comes in, just to focus the jury away from Logan McQuarrie's state of mind on this point and just remind them that the focus is Elizabeth Johnson's state of mind. So my request is for a limiting instruction as to state of mind, what the elements are after Logan McQuarrie's testimony.
Your Honor, I have no objection to a limiting instruction at the time you instruct the jury on the law. I do object to a limiting instruction after Logan McQuarrie testifies because it gives the appearance that the state will have done something wrong and that you're trying to fix it. I don't know how I feel about a limiting instruction before he testifies. That's not usually something we do. I think a limiting instruction at the time you instruct the jury is appropriate.
I tend to agree with the state. You'll get a limiting instruction at the time I instruct the jury, but I don't want to give it for the reasons Ms. Andrews set forth. I don't want to necessarily do it before either, because there are many times I could instruct the jury what's important and what's not, and I don't do it during the trial. I rely on an instruction at the time of the closing instructions to communicate to the jury what they need to focus on legally and what they don't.
Judge, just to take one more stab at it here, I think it could be done in a way after Logan McQuarrie's testimony that doesn't run into the concerns that the state raises, something along the lines of the testimony you heard today was testimony that was agreed upon by both parties and nothing came in that was improper. But I just want to caution you and then give them the information about state of mind. And the reason that I think it might be appropriate in this case is, as I've stated throughout my argument on this point about Logan McQuarrie's state of mind, this is a case, not just a high-profile case, but this is a case where there is so much potential prejudice that could flow from this notion that, wow, Logan McQuarrie was really in fear and now his baby is gone, the baby could be dead, there was a statement about the baby being dead, the baby's still missing. There's all this 403 prejudice out there that I think it might make sense, giving the very unique circumstances of this case. And so that's why my request is for what I would call a very neutral type limiting instruction that's just a reminder about state of mind, given that this is very powerful and a potentially confusing state of mind testimony for the jury as to the issues on this case.
I'm probably not going to do it. Let me see how it comes in and see how I feel about it once it comes in. If I gave it, I'd have the introduction you suggested, that there was no improper testimony was agreed upon. But as I'm thinking through it, it's unlikely I'm going to give it, but I'll be at least open to it based on what I hear in this testimony.
Okay.
Anything else on Mr. McQuarrie? Okay, Mr. McQuarrie, there's a host of things, and I don't expect you to remember everything, but let me just give you some broad guidelines in terms of where we're at. What I'm limiting you or telling you can't testify about are opinions about Ms. Johnson's parenting skills, what kind of mom she was. If you find yourself getting into that, don't do it. You might see me say stop, or one of the attorneys say stop. You're not to get into any of the 2 alleged incidents relating to the apartment or damage that she did, or the consequences, the fact or the allegation she went to jail. You can't get into that either. So you can't explain it, how something else happened the night that she came to your work or around that time. You can't put it into context by saying that's when she allegedly trashed the apartment. Be careful. You can't talk about that. You can't talk about an allegation that she didn't want the baby initially. She wanted an abortion. You can't talk about that. So those are the broad categories going forward. And just be aware if I say, wait a minute, that's what I'm talking about, if I'm limiting you at that time. Okay, Ms. Sorrentino just blocked you. Can you sit down on that side? Sorry, I'm talking to somebody right behind you. Do you understand what I'm saying? Yeah. Any questions about it? No. Okay, a couple other things just before you come up. I do note last time you got a pretty quiet voice, so when you come up and you're sworn in, make sure you're testifying slowly and project as best you can, okay? All right. What other issues do we need to talk about before we start?
Your Honor, there's one more thing, and just because I don't want it to draw an objection when it happens in court, we do intend to have testimony from Alicia Shumway, who worked for CPS at the time. Logan McQuarrie is the one who called CPS and made a report. Is our intention to only talk about the fact that he contacted CPS because he learned that Elizabeth Johnson was giving the baby to the Smiths for adoption.
And I think that that's fair game, because that's a big part of the story with Tammy Smith. Okay. Anything else before we break it for an hour for trial? Yes.
We have an issue in the transcript. I think it's the 1226 phone call between Elizabeth Johnson and Logan McQuarrie. I don't think we're admitting that. We have an agreement with the state to not admit any of the transcripts right now. I don't think we're going to play any of the audio right now. And just so the court's aware where we're going here, I think that probably what we're going to do is, because those transcripts are inaccurate and the audio is so difficult to understand, I think what we're planning to do is try to draft up a stipulation that includes statements that both sides agree are in there, that both sides want, that says something along the lines of the parties agree that these statements are contained within that recording, so-and-so said such and such, and just proceed that way through the stipulation. But there's a statement in there about kidnapping allegations being posted on Facebook. I don't know if the state's planning to get into that today or not.
Your Honor, based on an agreement we had, we weren't going to publish any recordings to the jury today until we figure out this transcript recording issue. From what I understand, and I haven't seen it and I don't recall it from the recording, Ms. Clark indicates that there's a statement Elizabeth Johnson makes to Logan McQuarrie where she says, "You put on Facebook that I kidnapped Gabriel." I don't think that's improper. The court previously precluded a statement Elizabeth Johnson made to Tammy Smith where she said that Tammy Smith's lawyer told her she was going to be charged with kidnapping and go to jail. And your concern about that was that a lawyer said it. Well, I will point out that Janet Morris, the person who said it, is not a lawyer. But regardless, there's some conversation in there about it being an attorney. This is Elizabeth Johnson saying to Logan that she heard he posted on Facebook that she had kidnapped Gabriel Johnson. I don't think that should be precluded. It's Elizabeth Johnson's statements to Logan specifically about this. And I don't even know that that's what it says. I don't recall that, and I don't recall seeing such a Facebook page.
Let's wait until we're at a time where that could be played. I've got my whole calendar waiting. Let's not get into an issue that we don't have to resolve right now.
That's fine, Judge. I just didn't know if the state was planning to bring it in today. That's why I raised it. Sounds like they're not.
Not this morning, clearly.
I don't recall that being, I don't recall seeing that in the transcript from previous testimony, so I discussed it with Logan. I don't know if he even recalls that being an issue.
Okay, all right. If it becomes an issue, we'll deal with it then.